Before we go into the Black Lives Matter movement and other issues, tell us what the stop and frisk challenge was and how you managed to actually end it.
Thank you. Well, thank you, Claire, for asking me to do this, and thank you, Wolfgang, and the whole ECCHR team. This has been a wonderful day, really talking about CCR's work through the lens of Michael. So I'm actually really happy to be talking about black and brown people right now. That makes me very happy. So I'm going to tell a slightly longer story about the stop and frisk case, because the stop and frisk case didn't start as a stop and frisk case. It actually, you heard Michael and Margaret talking about the importance of working with social movements. Back in 1999, there were very vibrant social movement groups in New York City. And there was, just like now, there was a spate of police killings of unarmed men, unarmed women, and there were massive protests within New York City. They were shutting down and getting arrested in front of the police station. They were getting arrested in front of the UN. There was a big, very much like what's happening these days. But a group of black and brown organizers came to CCR and had a very specific question. At the time, in 1999, there was a young African immigrant from Guinea named Amadou Diallo. And Amadou Diallo was standing in front of his building, and there was a group of police officers, a unit that was called the Street Crimes Unit. They didn't wear uniforms, and their job was to get guns and drugs off the street. But what they really did was they basically harassed the entire black and brown community in the Bronx, in Harlem, in Brooklyn, roughing people up, beating them up, doing that kind of stuff. So the organizers came to us and they said, is there a way that we can challenge this street crimes unit in the New York City Police Department? And so the first case that we actually filed was a case called Daniels versus City of New York, which was under federal civil rights law, a challenge, Section 1983, a challenge that was trying to end the practice of street crimes unit police officers and how they were destroying the black community. So what happened was, right around 2002, 2003, we got into a settlement, and we had been getting police data about how the street crimes unit and the police officers were stopping people. So we settled the case actually in 2002, and the New York City Police Department said, "You're right, we'll never do this again. Hey, let's have a anti-racial profiling policy." We said, "Great." And so we entered into it, and it was fine. And we were basically monitoring that. As we were monitoring that, and this ties into that last panel, one of the things that's really important to remember about both racial justice and criminal justice in the United States at this moment is that it all happens in a framework of a post-9/11 America. And so there's no such thing as regular policing anymore. There's no such thing as regular immigration policy anymore, and there's no such thing as any of those things. These are all now appendages and have been fortified and put on steroids by post-9/11 policy. So what we noticed is that in 2002, as we were monitoring to 2007, that stop and frisks were not going down, even though we had the settlement. They were actually going up. And by the time we got to 2011, we had an all-time high of stops. Almost 700,000 people were stopped each year. So we had entered into a consent decree with the New York City Police Department. We tried to get out of the consent decree and say, look, you're actually not complying with what you said you were going to do. The judge said, no, I'm not going to get them out of the consent decree, but if you want to file a new case, why don't you go ahead and file a new case, which we did. And the new case was Floyd versus City of New York. And rather than having the street crimes unit as the focus of that case, because they had disbanded the street crimes unit even though the stop and frisk went up, it was a pure stop and frisk case that was filed under the 14th Amendment and the 14th Amendment and the 4th Amendment. So yes, non-Americans. So under the Constitution, there are a lot of amendments. The Fourth Amendment is the one that keeps you free from unreasonable searches and seizures. The 14th Amendment is the one that bars state entities from discriminating against one group versus another, particularly if they're a protected class. African Americans and Latinos in this context are protected classes. we found through the statistics that we had that 87% of the stops that were happening were black and brown people. We also found that the black and brown people were stopped more almost no matter what the circumstances were. So if it was a black neighborhood, black people were stopped more. If it was a white neighborhood, black people were stopped more. If it was a mixed neighborhood, black people were stopped more. Poor, middle income, rich neighborhoods across New York City. How do we know this? Because we actually got the data from the New York City Police Department. So they gave us the rope to hang them with. I want to just take one step back, going to the movement question. I want to just sort of put this out here for later comments. We were talking about, Michael and Margaret were talking about social movements. And what has been, I think, marked, what I've been very proud of in my tenure, and I know Michael was very proud of at CCR, is that white movements and black movements operate very differently. And it's not the same social movement. The white left is different from the black left. And black movements tend to be more locally focused, particularly around issues of policing or around housing. And they don't really operate as mass movements. They operate as community groups or coalitions. So part of our challenge in thinking about taking on this work was not necessarily replicating the model of how mass movements used to work in the post-war years. It was about really building new relationships, the way that people are organizing now. So the step back that I want to take is back in 2000 in Cincinnati, Ohio. There were about 16 police killings of black men during a short period of time. So 16 different lawyers took those cases and filed civil actions, and they all ended up in front of the same judge. And the judge looks at these cases and she says, we have 16 cases, all involving the Cincinnati Police Department. I'm not going to litigate these cases separately. This is actually a systemic problem. Let's think about how to do this differently. So in Cincinnati, they pulled together a joint reform process which brought the police department, the community groups, movement groups, religious groups, all of the stakeholders in the community to think about how this process should get reformed. So it actually didn't get reformed in a litigation model, although litigation was brought in. It got reformed through bringing in the right stakeholders in. And I want to just put a pin in one thing. When you're doing police work, my view is that the biggest impediment to police reform are police unions in America. Unions work very differently here and in Europe than they do in the US, but the police union, the law enforcement unions, are actually the ones that will try to undo any type of reform process. And they actually tried to undo it in the stop-and-frisk case. So the reason why I'm telling you about Cincinnati is because that reform process was fairly successsul. So moving to CCR in 2013, when we win the stop-and-frisk case, a federal judge in a almost 200-page ruling excoriated the New York City Police Department for their racist practices. But the other thing that happened was we were able to pull together that group from Cincinnati to ask them how did they do that reform process in Cincinnati, what made it so successful. And then we were able to put that in our papers and suggested to the judge that if you find that stop and frisk is unconstitutional, which he did, you should think about a reform process that looks like that. And that's the reform process that we're actually in right now. So in our reform process, we have a coalition of the lawyers, which are us, a range of community-based groups. The police union is involved, the police brass is involved, the mayor's office is involved. So and the most important piece is that the community groups are at the table now. They're defining what they want policing to look like in their neighborhoods. So it's the first time through a judicial order litigation after a trial where the judge has ordered that community groups come to the table to help define what the new era of policing looks like.
Thank you. And only a year after this victory in the court in New York, the killing of Michael Brown in Ferguson, Missouri, happened by a white police officer. And shortly after this happened, and after protests started happening, CCR sent people on the ground. And tell us of the importance of having sent people right away as this was happening there. What was your idea when you decided to do that? what did you see, and what did you manage to achieve in terms of legal solidarity work, even how that parallels actually with the Guantanamo efforts?
Yeah, so as I was mentioning that black folks tend to organize differently than white folks. So when Michael Brown was killed in Ferguson, it was not a movement response. What it was a neighborhood and community response. So Michael Brown, as you know, was killed by the police. He laid on the ground for 4 hours while they decided what to do in front of the Canfield houses, and people were deeply upset about a long history of racial antagonism with the police department. His body was treated badly, and then almost immediately, as a counter-narrative, which police unions and police departments do, they started talking about him as a criminal, right? So what we see in police-based killing and police activity, particularly with black and brown people, is that black people and brown people become the defendants in their own death. Right? This happens all the time. You never hear anything about, well, more recently you're hearing, gosh, we're sorry, we shouldn't have shot this guy. But the first thing that you hear is, well, here's what he did that justified our shooting. So this is what happened with Michael Brown. The important thing to remember is that as a community response, there were initially no professional organizers that were there. There were no national groups that came. These were people that lived in that community, and they were confronting the police because this has been happening too long. Mike Brown was one kid too many from their neighborhoods. So now you have non-professional organizers that are confronting the police. You've seen all of the pictures. Then people start coming to the protests to join them. What we did was we realized that we're not from Ferguson. Ferguson, just so you know, is a small little town outside of St. Louis, Missouri. No one has ever heard of Ferguson before. No one had ever heard of it. And what we did was through the Birth of Justice initiative at ECCHR, which was put together, that I think Tony talked a little bit about the origins of that. And Jen Robinson and Tony have been very gracious in allowing us to be flexible about how the Birth of Justice Institute works. So the idea is that we shouldn't just be doing the law for law's sake. We shouldn't just be training law students, that when things like this happen, it's an opportunity to get on the ground. And so we were able to send our staff and some of the Birth of the Fellows to Ferguson pretty much right away, about a week after Mike Brown was killed. And we didn't go in with a game plan for what we were going to do. We didn't go in with an idea of what kind of lawsuits we were going to file. What we did was we actually spent time on the ground with the organizers, and we were building relationships with them, and we asked them, well, what do you guys need? So here's what they said. They said, we've never seen anything like this. We've never done anything like this. Here's our problem. We are protesting every single night. And every single night, we're getting tear gassed, we're getting beaten, and we're getting arrested. And when they arrest us, they don't put us in the local Ferguson jail. There are about 91 different towns that ring St. Louis. And what they were doing is they were arresting people, and they were putting them in different jails in different parts of the county. And so they said, as an organizing tool, if we don't have the people that can get out of jail and come back, this protest is going to be over relatively quickly. And they also said there were a lot of folks that were coming in from out of town, a lot of white folks, a lot of national folks, and they said that's great, but it's really most important that the people from this community are able to show up and everybody's in jail. So through a process that we developed with the National Lawyers Guild, we created the Ferguson Legal Defense Committee. And the idea there was to identify the different challenges that the organizers were having, and then to recruit lawyers from out of town to be able to come and to fulfill some of those things. So some of our lawyers were training the St. Louis lawyers on how to represent people in protests. Other lawyers were stationed at each jail just to be able to document who was coming in and who was not. They were partnered with St. Louis lawyers because you have to be admitted in Missouri in order to actually take the cases to trial, and none of us are in Missouri. So the volunteers were paired with local lawyers in order to be able to get the local lawyers to do the cases not just in a transactional legal way, but to be really responsive to the movement. Some of the lawyers were then documenting the human rights abuses, different things like that. One thing I want to say about Ferguson, this is why this is not a professional kind of movement that was happening. When people were going to the protests every night, they were bringing their children. They were bringing their grandparents. Now, people that do protest work for a living know that you don't bring kids to protests like that because crazy stuff is going to jump off. People will get tear gas, rubber bullets, people will get killed. But these were family members. This was their community. And they wanted their children to say no to the police officers as well. So there was a very, there was a very local and intimate sense that the people in Ferguson wanted to be in control of these types of protests. So our job as lawyers was not to just rush in and start filing different things, but to really start having these conversations and most importantly, building trust so that when these issues emerge, they would come to us and say, can you help with this? So just connecting it to Michael and Guantanamo, so we recruited about 200 lawyers from around the country to be able to come to Ferguson. And what was really phenomenal about it was that there were a large number of black lawyers. You know, Michael had talked about how Bill Kunstler, when he first got involved at CCR, he wasn't radical, he was a liberal. And so there were a lot of liberal black lawyers, people that worked in law firms, people that drove down from law school, didn't know what to do, where do I sign up? They knew that this was wrong and they wanted to enroll themselves in it. And so we were able to deploy them in strategic ways, train them in order to be able to do this. This kind of work. Yeah, and the law for black. So then how that then translated the following year. So remember I talked about how black folks organized a little bit differently. So Ferguson is a small little town, sleepy town. We also, as part of our work, brought in some national organizers, including the people that had started the Black Lives Matter work to Ferguson. We brought Harry Belafonte, who was a famous musician and activist from the 1960s, into Ferguson to begin to have some discussions. What's the national strategy? What's the local strategy? How does that begin to work out? After the national organizers got together, a tremendous thing happened the following year that has not happened, as far as I know, in the history of America, which is that the year after Mike Brown was killed, the organizers, just black organizers, decided that they were going to hold a huge conference in Cleveland, Ohio. And so 1,600 black organizers came together, and they basically, out of that conference, created the Movement for Black Lives, which was an extraordinary situation where we now have young black folks. It's women-led, it's queer-led, folks that are coming together around these issues. And what they're trying to do is they're trying to get rid of the old-time civil rights groups that have been doing this work. They don't want to hear about the churches, and they don't want to hear about Reverend this, they don't want to hear about that. What they want to do is they want to start confronting these things from an intersectional perspective, and that's what they came out of. So again, because of the Birth of Justice Institute and the flexibility that we were able to, that the Bertha Foundation was giving to us, after the big convening in June of these black organizers, then we created a lawyer convening in August called Law for Black Lives. And the idea of the lawyer convening was to be able to get, we were thinking probably 300 lawyers, hopefully mostly black, to be able to come to this conference. And the substance of the conference was going to be dictated by the substance of the movement demands that were coming out of the organizer conference, right? So it's, you know, putting on these conferences is really difficult. Everybody wants an agenda. What are you going to talk about? What we were going to talk about was what they were talking about as soon as they told us what it was. So it was hard to pull together. So here's what happened. Not only did we get a large number of black organizers to come essentially train the lawyers on what the movement issues were, we then also, within that conference, conducted trainings of the lawyers, and we had about 1,000 people that came to that conference over 2 days. I was really expecting 300. A lot of folks came. 60% of the people that came identified as black or of color. 55% identified as women. And it wasn't just lawyers from law firms, it was law students, it was people who had been in jail and had acted as jailhouse lawyers, it was legal workers. Everybody came together, and it was really moving for me because I had never been in a space with so many black and brown legal advocates before, and it was pretty extraordinary that CCR was able to pull that together. So the point there is that as there are hard litigation strategies like stop and frisk and the firefighters case, but then there are movement building strategies. Bahar talked about this a little bit before. What we try to do at CCR is we try to fight power, and those are the big cases when Barack Obama decides that he's going to target Anwar al-Awlaki for drone strikes, even though he's an American citizen. We file that case. They bring people to Guantanamo. We file that case. That is a fight power case. But then we have the build power case, that in responses to these things, that we are trying to strengthen three things simultaneously as a little tiny organization. Number one, we're trying to strengthen the movement that is developing on the ground. Number two, we're trying to strengthen the field of lawyers as they relate to movement folks. And number three, we're trying to train lawyers and bring lawyers to this kind of discussion. And I think Law for Black Lives was a really good example of how that just happened fairly spontaneously and quickly.
Thank you. It's really very inspiring. And I remember as all this was developing, I was really at awe that you pulled that off. And yeah, and so we can see there's a huge movement happening, and yet at the same time it's clear that any way of resistance is considered as violence by the police and by the state in the US. And one of the latest illustration of that, I could barely believe it when I first heard about it. I had to double, triple check that it's true, but so everyone knows of this Black Lives Matter movement, but now there's like Blue Lives Matter laws that are being passed by states. It's just so provocative, you can't make it up. And these are legislations that bring in, that make the targeting of police officers a hate crime. Tell us about this maybe in a few minutes, and then I'll take questions from the floor.
So yeah, the Blue Lives Matter is an appropriation of Black Lives Matter, and basically law enforcement, as you all know from your work, anytime that you have some measure of success on the massive social movement scale, power pushes back. And this is the way that power pushes back, by saying it's not just Black Lives Matter, Blue Lives Matter as well. They see Black Lives Matter as anti-police, so therefore there's now a groundswell of support for blue. The police officer uniforms in the U.S. tend to be blue, so that's why they call it Blue Lives Matter. But the way it's so bizarre, I can't get my head around it. So this is the way that hate crimes statutes work in the United States generally. If you commit a crime, if you beat somebody over the head, you're charged with assault. If you beat somebody over the head because of a racial animus, of a gender animus, of a religious animus, if you're doing it because they're of their status, in some states you get a enhanced penalty. So you get more time for beating somebody over the head because they're Muslim than if you do when it's not because they're Muslim. And there are challenges even with the hate crimes laws, and there's a critique around them. But that's generally how it works. So what happened in the Blue Lives Matter context is that the police unions got together and they started pressuring state legislatures to make an assault on a police officer a hate crime. So think about this. If you were dumb enough to assault a police officer, even if it wasn't a hate crime, you know that you're going to jail, right? You might be going under the jail, right? The police officers are the one group in America that actually don't need more protection. A lot of us need protection from police officers. But what they've done is now, this has happened in Louisiana and it's happened in a couple of other places. They've now enhanced the penalty for an assault on police, firefighters, or other emergency responders. So the idea there is that even though it's technically not really enforceable because you're going under the jail if you're dumb enough to hit a cop, what it does is it sends the message that police officers, that state legislatures and police unions will do anything to give police more protections than the average citizen, even when the police departments are the ones that are the aggressors and doing this. So the way that it works is that if a police officer beats you, that police officer is likely not going to go to jail because no one is going to prosecute the police officer. If you beat a police officer, then you're going to go to jail longer than you would have before this. And there's one more thing I want to say, which is crazy, and then we go to questions. have you guys heard of the concept of lynching? This came out of the Black American South, and that is back well, I won't say back in the day, when black people were arrested, very often falsely arrested for things like raping white women. This is that instead of going through a normal process, what would happen is the townspeople would go and intercept the person before he got to trial or to jail. They would take him, and they would, or her, and they would hang them by the neck, just kill them. Extrajudicial killing, I think, is what we call it in international human rights law. And but it wasn't just killing, it was beating, it was raping, it was mutilation, it was this horrible stuff. So they created anti-lynching laws in the 1870s that basically made it a crime for you to take somebody out of police custody in order to do this type of thing. Well, in Oakland last year, and this might be the first time this has ever happened, a black woman was charged with lynching in Oakland, California, for the following thing. She is a protester. She's been doing this for a while. Her friend or partner, I'm not sure, they were on the front line. The police officer grabbed her friend. She then held on to her friend because she didn't want the police officers to take her. And for that act, they charged this black woman with lynching. Went to trial. So just to give you a sense of, again, how we started this off talking about how the law is a tool of the rich class. It is both a tool that oppresses and that there is some possibility to be able to flip that. But this is a classic example of that even in the context of protest, righteous protest about police killings, that where there's almost complete and total impunity, the penalties for the protesters, even through formal aspects of laws, are increasing.